We seem to be having a disagreement here on how the DHS memo is written with this comma or thing. Okay, so here is the actual memo, going all the way down and reading everything. Now, I'm not sure why sections are blanked out. This is the actual PDF file. All right. I posted a link. I will post a link to this file. Now, it says clearly, photography for news, advertising, commercial purposes is governed by 41 CFR 142-74-420. In October of 2018, the FPS, which is Federal Protection Services, dismissed an FPS information bulletin HQIB-012-2010 field addressing photography of exterior facilities. The purpose of this bulletin was to remind FPS personnel and PSOs that public has the right to photograph exterior facilities, federal facilities, from public forums. Since the publication of the bulletin, FPS has experienced an increase in public's interest in photography and videotaping both exterior and interior of federal facilities protected by FPS, to include individuals expressing their First Amendment protected rights by initially photographing and videoing the exterior and interior of federal facilities. Law enforcement, in the course of their duties, to test FPS law enforcement and PSO response. Also, new case law impacts in interpretation and implications of the FPS enforcements. To address these increase in photography, videotaping by public, the Operation Readiness and Order maintains see the word very well. Relates the 2010 guidance, proving classification the public's right to photography of publicly access federal facility buildings, entrances, lobbies, foyers, corridors, auditoriums, and directs FPS law enforcement personnel and PSOs to maintain security without adversely impacting the public's right relating to photography and videotaping. For properties under protection of jurisdictions of FPS, the current no general security regulations prohibiting exterior photography of any federally owned or leased building absent a written local rule or regulations established by court security committee, or in limited cases a facility security committee. Furthermore, it is important to understand that 41 CFR 142-74.420 does not prohibit photography of individuals of the exterior of federally owned leases facilities. Rather, this regulation describes when an individual may photograph an interior federal building, space occupied tenants or building entrances and lobbies and foyers and corridors or auditoriums. This is where the problem seems to be, is this little comma thing. Okay? Everything before the comma is part of the list, including the word auditoriums. It ends the list. It's a period after auditoriums. It's not a period after corridors. If there was a period after corridors, then you could make the argument that that is excluded. It's not. It is part of it. Comma or, in legal terms, is the same as just using the comma by itself or putting an or in there. It doesn't matter. Okay, now the blocked out sections, I don't know what they say, because this is the actual document. As a reminder, photography and video absent a criminal precedent is a First Amendment protective activity. Photography of the interior of facilities. Okay. Title 41, Section 102, I'm not even going to read that again, of the Code of Federal Regulations provides federal policy concerning photographs for news, advertisement, or commercial purposes. It states, except where security regulation rules, orders, or directives applied, or a federal court order or a rule prohibits it. Persons entering in or on federal property taking photographs of leisure spaces, occupied by tenant occupancy for non-commercial purposes only for permission of occupying agency concerned. Space occupied by a tenant agency for commercial purposes only with written, clear word, written permission of an authorized official of the occupying agency concerned. Buildings, entrances, lobbies, foyers, or auditoriums of news purposes. These are the rules. And C is actually separated from the other two. A and B are their own. Apply this regulation to FPS protected federal facilities. FPS law enforcement personnel and PSOs should considering the following information when contempting enforcement of the regulation. Except where security regulations, orders, or directives apply to a court order or rule prohibits it. Persons entering in or on property may take photographs of. Application. This is how it's applied. Photography and videotaping of an interior of a federal facility is allowed. It's the conditions set forth in A through C of the regulations unless there are regulations, rules, orders, directive, or a court order that prohibit it. So if a court says you cannot film in this building where it has entrances, lobbies, foyers, corridors, or auditoriums for new purposes, if they're not allowed in there, the court order will rescind that capability. They will not be allowed to film in there. Then you have classified stuff. All right. For example, the SSA has rules that prohibited photography and videotaping in its spaces. Similarly, many courts issued no photography or videotaping in courtrooms and surrounding areas. The prohibition must be clearly posted and or actual in-person notice must be given. If the security guard tells you no, then it's no. If there is a sign on the front wall, it's no. You can't do it. These are held. Then you have your spaces. This is everything that's defined. All right, and I'm not going to read all this, but let's go to the fun line. Option C. Encouraging this fact, the public is allowed the photography, interior building, entrances of lobbies, covered areas. For example, someone can photograph the common spaces publicly of an accessible lobby. All right, of a federal facility. If an individual is authorized to photograph or videotape the interior federal facility, as discussed above. All right, so if the conditions are met, that's about as far as they can go. But then you refer back to the top over here, because it says it in this line, application. But these are examples of conditions. This right, however, does not authorize a photographer or interlude on restricted space surrounding a security post, create loud or unusual noises, or cause a nuisance, obstruct the usual use of entrances, lobbies, blah blah blah, impede or dispute the performance of official duties by the government employees, federal contractors, including PSOs, nor prevent the public from obtaining general services provided in an untimely manner. Other words, very basically, if you are filming at the counter at the post office, say, where people are making transactions, you are disrupting their business. You are the providing threat to their personal information. Not that the line goes, if you don't want to be, if you want to keep your privacy, you can't go in public. There is reasonable clue or reasonable expectation of privacy even in public. All right, you are clearly allowed to have private conversations in public, to conduct business transactions in public without a third party coming in and interfering with you. By doing so, you are causing the disruption. You, as the First Quote Amendment auditor, are going out there and becoming the instigation of a problem. That is how it works. I know you want to play around with all this little fun stuff, but it's basically clearly written. Like I said, this is the full menu. Alright, got more sections blacked out, more blacked out. Okay, we're not going to read it where Operation Readiness Order becomes effective. And that's the old part, probably the old memo. Now, I'm not sure why sections are blacked out. I can't tell you. I didn't black them out. But I will post this video.